Good evening, folks. Welcome to Friday Night Fun Night on Kirk's Law Corner. Hope everybody had a great week of, rain here in Idaho, or snow in certain areas of Idaho. I don't know about the rest of y'all, but been quite a cool, wet, weathery week, but we're still here. Wait for some people to join here. Thank you all for being here. Thanks for the likes, the follows, the shares, and over here on YouTube, thanks for the subscriptions and the thumbs up. Greatly appreciate it. And the shares, I guess some people have been having a hard time sharing over here on YouTube, but I don't know what that issue is, but I apologize. I'm not anything that I'm doing, not that I'm aware of. Everything's been the same pretty much on YouTube, and Facebook at the same time. So, sorry for any issues that you're having with trying to share, but out of my control. From my end, I can share my videos, so I don't know what kind of issues other people are having, but I have my own technical difficulties with computer stuff, but not with sharing on YouTube. So I want to thank everybody for that has supported before, and of course all those on the team and behind the scenes here and there. Thank you all for being here and the support and everything that we're doing, especially at the office with the team. It's just amazing what we're able to accomplish and what we're getting accomplished, and it's rather huge. It's been a huge undertaking to gather all the evidence that we have gathered and every single name of who did what, where, and when regarding what happened in Idaho. And that's what Kirk's Law Corner is working on, to deal with the issues that we have here, that the usurpations of power and subversion of law, sedition, treason. And we're getting real close to filing a criminal complaint. Not civil, criminal. So it's going to be some interesting times here pretty soon. So again, I want to thank all the supporters. But if you'd like to help support the channels here and keep them going, help pay the bills, I'd greatly appreciate it. For those postal money orders, regular money orders, cashier's checks, personal checks, anything like that, gold, silver coinage, any law books or anything like that you'd like to send to the office through the snail mail over there at 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. That'll get you over to the office. Digital side of things is my PayPal is Kirk_Pendergrass at hotmail.com. I also have the Cash App, and it is the $, capital K, capital P, lowercase en 71. And again, that is case sensitive. And then over on Patreon, if you'd like to join up over there for our Wednesday night workshop, that is from starts at 4 p.m. Pacific time, 5 Mountain, 6 Central, 7 Eastern. I moved that time to help other people get on there. But yeah, if you'd like to get over there on Patreon, it's patreon.com/Kirk's Law Corner. Become a reoccurring monthly support over there on that, as well as getting into the tier 3 and tier 4 for when I seriously kick off just just basics, teaching people how to do these documents and that kind of stuff. I did a little bit on Wednesday night with the criminal complaint form, the A091 form, kind of laid it out how to do that. But there's a lot to learn when it comes to doing paperwork to effectively defend yourself in your own personal case. So that kind of stuff is going to be in the tier 3 and tier 4. And I'm actually kind of enjoying the amount of people that are showing up. Last week we had quite a few show up, and it was a great night. We ended up going till about 8:30. So love you guys. Thanks for being there. And yeah, if you'd like to get on Patreon so you can get involved, you know, it's kind of like I was saying there the other night, is, you know, basically is building another team on the side, right? A team of law gurus. Teach you guys how to effectively defend yourselves and go after the bad guys. Because the maxim of law here is the defendant by pleading or exception becomes the plaintiff. And we need to learn how to become the plaintiff. We a lot of times, including myself, in the past have gotten stuck in this victim stance and not, and of course it's from lack of knowledge, right? We just don't know what to do. I mean, they haven't taught us how our form of government is supposed to work. They haven't taught us what our rights are, what the remedies are, how to redress our grievances with bad actors in government or bad policy, you know, that remonstrance. When we're talking about making bad policy, that's a remonstrance. When we're talking about wanting to alter, reform, or abolish something, that's a petition. Petition has a prayer for relief. The prayer for relief is where we make our demands. We instruct our representatives to perform specific duties under the terms and conditions of the contract of employment or holding of office. You know, this goes back to our rights, the right to all political powers inherent in the people, and that we have the right to alter, reform, or abolish anything and any time we deem it necessary. And the fact is specifically says right here that there shall be no privileges or immunities that shall ever be granted that cannot be altered, revoked, or repealed by the legislature. That's Article 1, Section 2. That's the Bill of Rights, a Declaration of Rights. For Idaho, that's laying down the law. That is the law. Not statutes, not codes, not rules of procedure, not regulations, not city ordinances. Article 1, see, they've duped us, they tricked us. Well, that's the Constitution. No, it is not. That's the law being laid down, because declarations lay down the law. Law is that which is laid down, ordained, or established. That's it. Enactments of the legislature are not law of the land, period. It's a fact of law. It's a fact of our form of government. I know that's a hard concept for a lot of people to comprehend and understand, stand in agreement. But that's not how our form of government is supposed to work. It's not how we make law. That's not law. At best, it's policy. And in reality, according to Title 18, United States Code 241, it says color of law, statutes, regulations, ordinances, right? That's color of law because it's not law. For them people out there to say, well, when we make that we're making law and that has the force and effect of law. No, it does not. That's color of law. It looks like law, but y'all don't have that authority to make that as law. That's not how we make law. Declarations lay down the law. And again, American Jurisprudence, Volume 16, Constitutional Law, Section 100, Bills of Rights, and those merely declaratory of the common law. Wait a minute. That means the common law is already there. It's the fundamental law. That's part of the law of this nation called America. That came first, like it says in Hale versus Henkel. that our rights are long antecedent to the creation of the state or government. Hello? I mean, think about that. If our rights are long antecedent to the formation of government, isn't that the law? The actual law? Law of the land just literally means due process of the law. Oh, wait a minute. Yeah, because law of the land and due process of law are synonymous. They mean the same thing. So when we look at the constitutions, because if we read the Declaration of Independence, there's a declaration, declare, D meaning down, clarify. The thing is using declarations is how we lay down the law. And like it says in the Declaration of Independence, it specifically says to secure these unalienable rights, life, liberty, and the pursuit of happiness, is among these rights. And that to secure these rights, governments are instituted to, right? Receiving their just powers under the consent of the governed. So those that are destined to be governed by the Constitution, you have to have consent of the governed, and you have to receive those just powers. And they have to be delegated by Constitution. That's the bylaw. That's policy. And this is even American Jurisprudence, Volume 16, Constitutional Law, Section 1, where it says constitutions are more like statutory law. Now, there's some pretty interesting things that I have found in researching Idaho, is that how it was actually created was first you have the Organic Act for the territory. That's right, it's a territory of Idaho, not the state, the territory of Idaho, not the territory of the United States. So this is the territory of Idaho that I live in, that I'm domiciled in, that I am a resident. I know some people don't like that word, but that's because it's been twisted by the bar and turned into something totally different than what it actually means. Just like a lot of other words, and Chris and I used to talk about word salad. So then after what is the Organic Act? Well, here we go. Let's pull this sucker up. Plug it in. Oh, had to plug in the drive there. I can pull this up. Oh, let's see. Where are you at? There, right here. All right. Ugh, I'm going to get to it now. Actually, I'm going to do it like this again. All right. So according to Article 4, Section 3, which we'll go to that real quick. Let me explain how this works right from the due process of law, the supreme law of the land. This is the supreme due process of law here. This is the law of creation, right? We right here. We the people. We create. We create this stuff. But see, how does this work? Article 4, Section 3, admission of states. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned, as well as of the Congress. This is part of the federalism of how this works. The Congress shall have power to dispose of and make all needful rules and regulations, rules of procedure and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Now, this is one of those parts where people have used this that says, oh, well, then it's, the federal government has jurisdiction over. No, because watch what happens here. In the Organic Act for the Territory of Idaho, they give up the territory belonging to the United States to the people of the territory. And then we have to fully comprehend Article 1, Section 8, Clause 17. Scope of legislative power. Right here. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square. Whoops. As made by session of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state. Now, pay attention to the words here. In which the same shall be for military purposes, for the erection of forts, magazines, arsenals, dockyards. Well, they got to have dockyards. For what? For the ships, the vessels, and other needful buildings. Okay. So in the territories, they would have to have the consent of the legislature to purchase the land to build, let's say, a federal district court. That would have to be seated. Okay? But it has to be done by the consent of the legislature of the state. And it has to be for forts, magazines, arsenals, dockyards, and other needful buildings. Buildings. Otherwise, they cannot own land inside the territory of a state. Period. That's the limitation we put on government right there, as it is written. It's not my opinion. These are facts of law. We're all reading it right now. Ignorance of the law is no excuse, and to know a thing and to be bound to know it are regarded in law as equivalents, a maxim of law. That's the rule of law. And then, of course, this was misconstrued. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Remember, we're talking about delegating powers under the just powers. They have to be delegated. They have to be itemized. Because if that power isn't delegated, then it doesn't exist. This is contract law 101. If I contract with you to paint my house, that's what you do. You can't come back and say, well, I chopped down your trees and, painted your fence and whatever. No, that wasn't the terms and conditions of the contract. Where did it say that? Well, it didn't say that I couldn't. Well, but it didn't say that you could. That's how contract law works. But see, between the bar and the judicial branch, which is basically one and the same, have said, oh, well, if the Constitution doesn't say that we can't do it, then we can. That's not how that works. That's a lie. You're deceiving the people, and you're doing it to create an advantage and extend your own powers to subvert the law of creation of government itself, the Constitution, which we're reading from right now. So, now that we know how a state is supposed to be created, I'll finish that up because they may be admitted to the union. Wait a minute, that's what it says, right? New states may be admitted by the Congress into this union. That's because all of the previous states have purchased the land by some sort of treaty. Those are those powers to make treaties to purchase land. But it still belongs technically to the people because the people of the territory are the ones that actually put up the money to buy the land. So, how this works is they make application to the legislature, Congress, and say, hey, we would like to become self-governed. We'd like to create our own form of government. Oh, well, you can't actually create your own form of government. We already have a form of government. But you want to become self-governed? Great. Gather up your people and get prepared for elections. But here's what we're going to do. We're going to create the Organic Act for the territory. We're going to delegate to you the powers that states have, because this is the power of Congress pursuant to the Constitution of the United States of America. This is how this works. This is how we guarantee a Republican form of government. It has to follow due process of law, the law of creation. So the first thing is to apply. Then they send out the Organic Act and say, here you go. These are all the powers you have. An act to provide a temporary government for the territory of Idaho, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled. That all the part of the territory of the United States, including within the following limits to wit, beginning of the point in the middle. Okay, now they're laying out the metes and bounds here. Okay. 49th parallel of latitude. What are we talking about? This is how it's supposed to be described. It's called metes and bounds, not lots and blocks. That's the scheme, scam, and fraud. So now that we can take a look at this and see how this is actually done, every single state, aside from the original 13, which those were done through corporate charters, like the first charter of Virginia, 1606. And be it further enacted that the executive power and authority in and over the said territory of Idaho shall be vested in a governor. See, they're telling us how our form of government is supposed to be. Who shall hold his office for 4 years and until successor shall be appointed and qualified unless sooner removed by the President of the United States. The governor shall reside within said territory and shall be commander-in-chief of the militia and superintendent of Indian affairs thereof. Period. He may grant pardons and respites for offenses against the laws of said territory and reprieve for offenses against laws of the United States until the decision of the President of the United States can be made known thereon. He shall commission all officers who shall be appointed to office under the laws of said territory and shall take care that the laws be faithfully executed. Faithfully executed. They don't get to make law. They are to execute the laws of the territory. Whoops, I got the wrong share there. There you go. I'll fix all that. All right. And be it further enacted. Now, see, again, these are enactments. But this is the organic law, the law of creation. This is the document that created government for the territory of Idaho. Okay. That there shall be a secretary of said territory, who shall reside therein and shall hold his office for 4 years, unless sooner removed by the President of the United States. He shall record and preserve all laws and proceedings of the Legislative Assembly hereinafter constituted, and all the acts and proceedings of the governor in his executive department. He shall transmit one copy of the laws and journals of the Legislative Assembly within 30 days after the end of each session, and one copy of the executive proceedings and official correspondence semi-annually on the first days of January and July in each year to the President of the Senate and of the Speaker of the House of Representatives for the use of Congress. Huh. Right here, that's saying they're supposed to do this twice a year. So this is an indicator when we go to, under Article 4, Section 4, to the Congress to protect us and ensure a Republican form of government. Huh. On application of the legislature, and if the legislature can't be convened, the executive. Well, who is it referencing as the executive here? The president. Unless sooner removed by the President of the United States. Same thing with the governor. The President of the United States has the power to remove these people. This is exactly what Article 4, Section 4 is talking about, because just like the governors, the president is the commander-in-chief of the military. This is how our form of government is supposed to work. These are the powers properly delegated. These emoluments are being created right here. This is the law of creation. All right. And be it further enacted, the legislative power and authority of said territory shall be vested in the governor and a legislative assembly. The legislative assembly consists of a council and a House of Representatives. The council shall consist of 7 members having the qualifications of voters, as hereinafter prescribed, whose term of service shall continue 2 years. The House of Representatives shall, and in its first session, consist of 13 members possessing the same qualifications as prescribed for members of council, and whose term of service shall continue 1 year. The number of representatives may be increased by the Legislative Assembly from time to time to 26, in proportion to the increase of qualified voters, and the council in like manner to 13. An appointment shall be made as nearly equal as practicable among the several counties or districts for the election of the council and representatives, given to each section of the territory representation the ratio of qualified voters. Okay, so we're seeing this being created here. See how this is our government's being formed, how it's coming together here. Be it further enacted that every free white male inhabitant above the age of 21 years who shall have been an actual resident of said territory at the time of the passage of this act shall be entitled to vote at the first election and shall be eligible to any office within the said territory, but the qualifications of voters of holding of office and all subsequent elections shall be such as shall be prescribed by the Legislative Assembly. Be it further enacted, the legislative power of the territory shall extend to all rightful subjects of legislation. Now, here we go. Rightful subjects of legislation, consistent with the Constitution of the United States and the provisions of this act. But no law shall be passed interfering with the primary disposal of the soil. No tax shall be imposed upon the property of the United States, nor shall the lands or other property of non-residents be taxed higher than the lands or other property of residents. Now, every bill which shall be passed the Council and House of Representatives of said territory shall, before it becomes a law, that's a lowercase l, be presented to the governor of the territory. If he approve, he shall sign it, but if not, he shall return it with his objections to the house in which it originated, who shall enter their objections at large upon the journal and proceed to reconsider it. If after such reconsideration 2/3 of that house shall agree to pass the bill, it shall be sent, together with the objections, to the other house, by which it shall likewise be reconsidered. And if approved by 2/3 of that house, it shall become a law. But in all such cases, the votes of both houses shall be determined by yeas and nays, to be entered on the journal of each respectively. If any bill shall not be returned by the governor within 3 days, Sundays excepted, after it shall have been presented to him, the same shall be a law in like manner as if he had signed it, unless the assembly, by its adjournment, prevent its return, in which case shall not be a law, provided that whereas slavery is prohibited in said territory by act of Congress of June 19th, 1862, nothing herein contained shall be construed to authorize or permit its existence therein. That's weird, because I thought that was already done in 1808. Just saying. And be it further enacted that all township, district, and county officers not herein otherwise provided for shall be appointed or elected as the case may be, in such manner as shall be provided by the governor and legislative assembly of the territory of Idaho. The governor shall nominate and, by and with advice and consent of the legislative council, appoint all officers not herein otherwise provided for. And in the first instance, the governor alone may appoint all said officers, who shall hold their offices until the end of the first session of the legislative assembly, and shall lay off the necessary districts for members of the council and house of representatives and all other officers. Lay off. Okay, but this also goes back to the very beginning, that what is the governor again? Isn't the governor, what is the governor here? Very limited scope and authority and power. Who shall hold his office for 4 years, shall be commander-in-chief of the militia and superintendent of Indian affairs thereof. He may grant pardons and respites for offenses against the laws of said territory, and reprieve for offenses against the laws of the United States. He shall commission all officers who shall be appointed to office under the laws of said territory, and shall take care that the laws be faithfully executed. What kind of officers are we talking about? Military. Huh. Kind of a limitation on the powers of the governor right there, ain't there? And the same thing with the legislative power. To all rightful sub-jurisdiction. This is why it's in the Idaho Constitution that there must be a unity of subject and title. You gotta have subject matter jurisdiction. Goes right back to the first fundamental principle of group decision making in the Mason's Manual Legislative Procedure. Fundamentally and principally, you have to have jurisdiction. And sometimes groups assume powers they do not have. That's what a remonstrance is about. Section 7, and be it further enacted that all township, district, county officers not herein otherwise provided for shall be appointed or elected as the case may be. So there's something in here that creates these county officials, right? Officers. We're about to see those. The governor alone may appoint all said officers who shall hold their offices until the end, blah, blah, blah. Be it further enacted that no member of the legislative assembly shall hold or be appointed to any office which shall have been created, or the salary or emoluments, there it is, salary or emoluments, those stipends attached to some office, to quote Attorney General Barr, under the parliamentary inquiry that Chris did. Remember that? When she asked Attorney General Barr, well, what's an emolument? Well, it's a stipend attached to some office. That's what we're talking about right here. Assigned to any office which shall have been created. We have to create the emoluments of the office. What are the advantages, profits, and gains that are received by sitting in that emolument? One's a salary. Well, if the emoluments of the office of governor have certain profits and gains, profits being the salary, the gains would be the gains of the just powers to pardon, reprisals, to execute the laws. All right. Of which shall have increased while he was a member during the time for which he was elected, and for 1 year after expiration of such term. But the restrictions shall be applicable to members of the first legislative assembly. No person holding a commission or appointment under the United States, except postmasters, shall be a member of the legislative assembly or shall hold any office under the governor of said territory. In other words, you can only hold one emolument at a time. You can't get paid beyond the clock as a legislator and any other position. Fundamentally and principally, that's how all of government is. You can only hold one emolument at a time. Section 9, and be it further enacted that now this is where it gets good. And be it further enacted that the judicial power of said territory shall be vested in a Supreme Court, district courts, probate courts, and in justices of the peace. That's it. Period. No de facto kangaroo courts. Now, I know there's a certain people probably watching right now, and this is exactly what we're talking about. The Supreme Court shall consist of a Chief Justice and 2 associate justices, any 2 of whom shall constitute a quorum, and who shall hold a term at the seat of government of said territory annually. Now, these particular people, especially the Chief Justice, is responsible for all of the other justices of the peace and magistrates, because they're not actually judges, they're magistrates. That's it. We got magistrates and justices of the peace. Somebody has fundamentally altered our form of government here in Idaho. You can't alter the law of creation and the powers delegated. This is where I say I think we need to return to some fundamental principles of law. This is the law of creation of government of the territory of Idaho. And this is what creates it. And it cannot be usurped unless it specifically says in here it can be changed, which there is a couple places where it does say that the legislature can change this, because this is just a general form of government. But there are certain aspects and parts of the government that cannot be changed because it's fundamental in its form and character, like this part, that the judicial power is being delegated right here. And it shall be vested in a Supreme Court, district courts, no magistrate division of the district court. You're all magistrates, so it's all the magistrate division. It's what it says in the Idaho Code, that we only have magistrates. They're all, every last one of you are magistrates, period. You're not judges. God is our ultimate judge. And the jury is a jury of our peers. That's about as close to a judge us as we're going to get. So, let's read on here because it gets quite interesting. And they shall hold their office during a period of 4 years and until the successors shall be appointed and qualified. The said territory shall be divided into 3 judicial districts. This would be them, which district previously ascertained by law? Bylaw. This is the bylaws of the corporation of the state of Idaho. This is, in fact, the bylaws, but it's called an organic act for the territory. So, 3 judicial districts and a district court shall be held in each of said districts by one of the justices of the Supreme Court at such times and places as may be prescribed by law. There it is. By law. They are bylaws, policy, because corporations don't have the power to make law. They only have the power to make policy, to regulate themselves pursuant to the law of creation. The people are at the top. Government and public servants are under the Constitution, not over. And the law was laid down prior to instituting government. So government understands our rights as the law. That's the way it's supposed to be. So let's continue reading here. They have to reside in the districts which shall be assigned them. But see, one thing back here is it says that, what is it? That these 3 officers, right? And then there's 3 judicial districts, and a district court shall be held in each of said districts by one of the justices. Huh. So this goes back to the chief judge, or pardon me, chief justice, and the 2 associate justices. Notice they didn't call them judges, right? So those 3 are the ones that are supposed to run around to the district courts. That's what it says here. By one of the justices of the Supreme Court at such times and places as may be prescribed by law. The jurisdiction of the several courts herein provided for, both appellate and original, and that of probate courts and of justices of the peace, shall be limited by law. So right here is a delegation of authority to the legislature to regulate these courts, which is right here. The district courts, the Supreme Court, the district courts, the probate courts, and justices of the peace. But wait, it gets really good. But see, this is where it says that it's prescribed by law, which is the legislature. Now it does say, okay, and the said judges shall, after their appointments, respectively reside in the districts which shall be assigned them. The jurisdiction of the several courts herein provided for, both appellate and original, and that of probate courts and justice of the peace shall be limited by law, provided that justice of the peace shall not have jurisdiction of any matter in controversy when the title or boundaries of land may be in dispute, or where the debt or some claim shall exceed $100, and the said Supreme and District Courts respectively shall possess chancery as well as common law jurisdiction. Oh, but common law is stare decisis. Whoops. Huh. No, I didn't. Sorry. But look at this. Doesn't that talk about the common law? It sure does. This is organic in character because this is the organic law, the law of creation. This goes right back to the 7th Amendment, or Article the 7th, suits it the common law exceeding the value of $20, the right to a trial by a jury shall be preserved. And no fact tried by a jury, not by a judge, by a jury, shall be heard in any courts of the United States, except pursuant to the rules of the common law. Are these not courts of the United States? I think the United States just created them. These are courts of the United States because they come from the Constitution of the United States of America. And they are to be limited by law. But notice it doesn't talk about the common law courts. But here's a common law jurisdiction, but it does say, where was it? When the title or boundaries of land may be a dispute, or where the debt or some claim shall exceed $100. So are the justices of the peace the common law courts? Where are our common law courts? Where are justices of the peace? Where are they? They were lawfully created here. Each district court, or the judge thereof, shall appoint its clerk, who shall also be the register in chancery, and shall keep his office at the place where the court may be held. Writs of error, bills of exceptions, and appeals shall be allowed in cases from the final decisions of said district courts to the Supreme Court, under such regulations as may be prescribed by law. The Supreme Court, or the justices thereof, shall appoint its own clerk, and every clerk shall hold his office at the pleasure of the court for which he shall have been appointed. Writs of error and appeals from the final decision of said Supreme Court shall be allowed, and may be taken to the Supreme Court of the United States in the same manner and on the same regulations as from the circuit courts of the United States, where the value of property, the amount in controversy, to be ascertained by oath or affirmation of either party or of other competent witnesses shall exceed $100 or $1,000, except that a writ of error or appeal shall be allowed to the Supreme Court of the United States from the decision of said Supreme Court created by this act. So even if you take something all the way to the Supreme Court of your territory, you can still go to the Supreme Court of the United States. That's what it says there, doesn't it? Sure does, as it is written. Or of any judge thereof, or the district courts created by this act, or any judge thereof upon any writs of habeas corpus involving the question of personal freedom. And each of the said district courts shall have and exercise the same jurisdiction in all cases arising under the Constitution and laws of the United States, as is vested in the circuit and district courts of the United States. And the first 6 days of every term of said courts, or so much thereof shall be necessary, shall be appropriated to the trial of causes arising under the said Constitution and laws. And writs of error and appeal in all such cases shall be made to the Supreme Court of said territory, the same as in other cases. The said clerk shall receive, in all such cases, the same fees which the clerks of the district courts of Washington Territory now receive for similar services. That's because Idaho was created out of Washington. And be it further enacted that there shall be appointed an attorney for said territory, who shall continue in office for 4 years, and until his successor shall be appointed qualified, unless sooner removed by the President of the United States. Again, right there, that the President of the United States has the power to remove these people, and who shall receive the same fees and salary as the Attorney of the United States for the present territory of Washington. There shall also be a marshal for the territory appointed, who shall hold his office for 4 years, and until his successor shall be appointed and qualified, unless sooner removed by the President of the United States. Again, that's the power properly belonging to the President to remove these officers under admiralty jurisdiction. And who shall execute all processes issuing from and said courts when exercising their jurisdiction as circuit or district courts of the United States. He shall perform the duties, circuit or district courts of the United States. Remember, back to the 7th Amendment there, shall not be heard in any courts of the United States. Told you. He shall perform the duties, be subject to the same regulations and penalties, and be entitled to the same fees as the Marshal of the District Court of the United States for the present territory of Washington, and shall, in addition, be paid $200 annually as a compensation for extra services. Now, this is where we have to comprehend what an attorney is. Attorney is one who prosecutes. This is the general prosecuting attorney and is supposed to prosecute on behalf of the people against public servants. They're not supposed to be prosecuting the people because fundamentally and principally, it's of the people, by the people, for the people, not against the people, fundamentally and principally. So this is the duty right here of a general prosecuting attorney for the people of the territory of Idaho. And be it further enacted that the governor, secretary, chief justice, and the associate justice's attorney and marshal shall be appointed by the president of the United States, by and with the advice and consent of the Senate. The governor and secretary to be appointed as aforesaid shall, before they act as such, respectively, take an oath or affirmation before the district judge or some justice of the peace in the limits of said territory duly authorized to administer oaths or affirmations by the laws now in force therein, or before the chief justice and some associate justice of the Supreme Court of the United States, to support the Constitution of the United States and faithfully to discharge the duties. What is that? To support the Constitution of the United States. That is means to uphold, not interpret. They're not supposed to be interpreting the Constitution. They're supposed to support it. Again, I like to use the analogy of the table legs. The legs of the table support the tabletop. What's on top of the table is none of the legs' business. They're supposed to support it. And in this instance, support the Constitution of the United States is exactly what it says in Article 6, Clause 3. Okay? So, in supporting something, you don't get to alter it. How can that which is created dictate to the creator what their scope and authority is? What their powers are? Completely illogical. And faithfully to discharge the duties of the duties of their respective offices, which said oaths, when so taken, shall be certified by the person whom the same shall have been taken, and such certificates shall be received and recorded by the said secretary among the executive proceedings. So, oaths of office are supposed to be with the Secretary of State. Right there, that's how our form of government works. No matter what office you're in, you have to take an oath of office, and it must be certified and sent to the secretary, recorded with the Secretary of State, or with what we would just call the secretary. That's the secretary, the recorder, you know, what they're supposed to do there. They keep the paperwork, keep the books and papers. So, and the Chief Justice, Associate Justice, and all civil officers in said territory, before they act as such, shall take a like oath or affirmation before the said governor or secretary, or some judge or justice of the peace of the territory, who may be duly commissioned and qualified, which said oath or affirmation shall be certified and transmitted by the person taking the same to the secretary, to be by him recorded as aforesaid, and afterwards the like oath or affirmation shall be taken, certified, and recorded in such manner and form as may be prescribed by law. That's power of the legislature. The governor shall receive an annual salary of $2,500, blah, 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 blah. Members of the legislature shall be entitled to receive $4 each per day. This was 1863, of course. $4 a day was pretty good money back then, I guess. During their attendance at the sessions thereof, and $4 each for every 20 miles travel in going to and returning from said session, estimated according to the nearest usually traveled route, and an additional allowance of $4 per day shall be paid to the presiding officer of each house for each day he shall so preside, and a chief clerk, one assistant clerk. That's those clerks that we would file remonstrances and stuff with. This is in the legislature. One engrossing and enrolling clerk, a sergeant at arms, and doorkeeper may be chosen for each house. Oh, that's right. Each house. So that's like the House of Representatives and the Senate. It's just called the House. And the chief clerk shall receive $4 per day, but no other officer shall be paid by the United States. Wait a minute. All of this is under the United States. That's right. Provided that there shall be but one session of the Legislative Assembly annually, unless on an extraordinary occasion the governor shall think proper to call the Legislative Assembly together. Well, that's Article 4, Section 9. There shall be appropriated annually the usual sum to be expended by the governor to defray the contingent expenses of the territory, including the salary of the clerk of the executive department. There shall also be appropriated annually a sufficient sum to be expended by the secretary of the territory, and upon an estimate to be made by the Secretary of the Treasury of the United States to defray the expenses of the Legislative Assembly. The printing of the laws. Fundamentally, principally in our form of government, who is it that's supposed to print the laws? And other incidental expenses, and the governor and secretary of the territory shall, in the disbursement of all monies entrusted to them, be governed solely by the instructions of the Secretary of Treasury of the United States, and shall semi-annually account to the said secretary for the manner in which the aforesaid money shall be expended, and no expenditure shall be made by said Legislative Assembly for objects not specifically authorized by the acts of Congress making the appropriations, nor beyond the sums thus appropriated for such objects. For objects not specially authorized by the acts of Congress making the appropriations. And be it further enacted that the Legislative Assembly of the Territory of Idaho shall hold its first session at the time and place in said territory as the governor thereof shall appoint and direct, and at said first session, or as soon thereafter shall deem expedient, the governor and legislative assembly shall proceed to locate and establish the seat of government for said territory at such place as they may deem eligible, provided that the seat of government fixed by the governor and legislative assembly shall not be changed at any time, except by an act of the said assembly duly passed, and which shall be approved after due notice at the first general election by a majority of the legal votes cast on that question. So see, here's another prima facie evidence that they really don't have the authority to make all these decisions. They have to have the consent of the governed, those that are registered to vote. It's got to be approved by the people, by a majority of the people. Be it further enacted that a delegate to the House of Representatives of the United States to serve for them or for the term of 2 years, who shall be a citizen of the United States, be elected by the voters qualified to elect members of the Legislative Assembly, who shall be entitled to the same rights and privileges that are exercised and enjoyed by the delegates from the several other territories of the United States. Well, why is this not called other states of the United States? Because it's other territories. They are territories. Just saying. Let's see. But the delegate first elected shall hold his seat only during the term of the Congress to which he shall be elected. The first election shall be held at such times and places, blah, 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 blah. Person having the greatest number of legal votes, the constitutional and all laws of the United States which are not locally inapplicable shall have the same force and effect within the said territory of Idaho as elsewhere within the United States. And be it further enacted that when the lands in the said territory shall be surveyed under the direction of the government of the United States, preparatory to bringing the same into market, sections numbered 16 and 36 in each township and said territory shall be, and the same are hereby reserved for the purpose of being applied to schools in the said territory and in the states and territories hereafter to be erected out of the same. And be it further enacted that, until otherwise provided by law, the governor of said territory may define the judicial districts of said territory and assign the judges who may be appointed for said territory to the several districts, and also appoint the times and places for holding courts in the several counties or subdivisions in each of said judicial districts by proclamation to be issued by him. But the Legislative Assembly, at their first or any subsequent session, may organize, alter, or modify such judicial districts and assign the judges and alter the times and places of holding the courts as to them shall seem proper and convenient. And be it further enacted that all officers to be appointed by the President of the United States by and with the advice and consent of the Senate for the territory of Idaho by virtue of the provisions of any law now existing or which may be enacted by Congress are required to give security for monies that may be entrusted with them for disbursement, shall give such security at such time and in such manner as the Secretary of Treasury may prescribe. And be it further enacted that all treaties, laws, and other engagements made by the government of the United States within the Indian tribes inhabiting the territory embraced within the provisions of this act shall be faithfully and rigidly observed, anything contained in this act to the contrary notwithstanding, and that the existing agencies and superintendencies of said Indians be continued with the same powers and duties which are now prescribed by law, except that the President of the United States may, at his discretion, change the location of the office of said agencies or superintendents. The needful buildings, remember. Approved March 13th, 1863. Early History of Idaho, William John McDonough, Idaho, Legislature, published in 1915. So, now that we kind of hashed out Idaho and the things that were created, now we have to go to the next step. What is the next step? But it already talks about laws already, doesn't it? Well, how could there be laws for the territory before it was even created? There's some weird issues there, huh? So let's look at. Oh, wait. Where did I put those? There we go. Let's go with the first session for the Territory of Idaho. Ready to have your mind blown, folks? Stanford University Library. This is where came from, a copy of this. Ready? They have enough. Oh, what's this? Laws of the Territory of Idaho, first session, convened the 7th day of December, 1863, and adjourned on the 4th day of February, 1864 at Lewiston. That's right. Lewiston used to be the original capital. So, also containing the Territorial Organic Act, Declaration of Independence, the Federal Constitution, the Preemption and Naturalization Laws, etc., etc. Wait a minute. These are the laws of the Territory of Idaho, and it includes the Territorial Organic Act, which is what we just covered. Hereby certify that the laws contained in this printed volume are true and literal copies of the enrolled laws passed by the First Legislative Assembly, held during the months of December, January, and February 1863 and 4, on file in my office. Remember, isn't that what it said there in the Organic Act? Witness my hand and the seal of the territory hereunto annexed this first day of July, A.D. 1864. Notice that says seal of the Territory of Idaho. It has like a little picture there of the Union. What's going on here? How did we go from being a Territory of Idaho to the state of Idaho? Gee, why would this be as a law for the Territory of Idaho? Because these are the laws of the United States of America. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. It's amazing. I know that right off the top of my head. But let's back up. What does the law actually say here? When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. So we hold these truths to be self-evident. This is some common sense law. Common law. This is the law that is common to all. And this is a reason, right? Right here, should declare lay down the causes which impel them to the separation. We're declaring the characteristics and conduct of our enemy. And giving aid to our enemy is treason. So this is what we're looking at. These are treasonous acts of a tyrant, our enemy, our declared enemy. But remember, this book is the laws of the territory of Idaho. Why is the Declaration of Independence in here? Because that's law. Now, this is going to get interesting here because when we get down to the Bill of Rights, now remember, this is 1863, so we've already been in Civil War for 2 years, so it's quite interesting. What does that say? Article 1, not Amendment 1. Stephanie C. I hear on YouTube. Trying to let me back up a little bit here and see what you guys were actually talking about there. Who's the governor is presented. No, see, right here. It's right here. And to petition the government for a redress of grievances. Again, the right of the people to peaceably assemble and to petition the government for a redress of grievances. Now, to give further clarification, let's see if I can get out of this here real quick. Go back to here. Notice that we're under the right of assembly here. What does the right of assembly actually mean? So just like in mathematics, we can do it backwards and to check our work, right? It should mean the same thing backwards as we say forwards. So the people have the right to assemble in a peaceable manner, comma, to consult for their common good, semicolon, then to instruct their representatives, comma, and to petition the legislature for the what? Petition the legislature for the redress of grievances. See, you're confused. It's not to the lieutenant governor. I don't know where you got the idea to go to the lieutenant governor to file a criminal complaint, but nonetheless, right here, our right dictates to redress grievances, we go to the legislature with a petition. So when we go to the legislature with a petition, the petition is to call them into assembly so that we can consult for our common good. And so I can instruct my representatives to discharge the duties of that office. I get to dictate to them what to do. They're the servant. I'm the master. I'm the master of my own affairs. No, see, this is what the petition is. It is the instructions. Okay. You're confusing a couple of different things here. So, if you've had a crime committed against you, a felony or a breach of the peace, which is assault or battery, even by a public servant, they're not immune. They don't have immunity from committing felonies. They don't have immunity from committing misdemeanors or breaches of the peace. Heck, not even the legislators coming to and from or during the session are immune from being arrested. You have to file a criminal complaint, not Title 42, 1983, civil rights violations, a criminal complaint. Remember, they're all servants. Nobody's above the law. And there is absolutely no immunity, none, for committing crimes against the people. See, like, say, for instance, the governor can technically speaking, only be removed by impeachment. That's for moral turpitude, not for committing felonies. No man is above the law. We don't go through impeachment for felonies. That's a criminal complaint and a warrant for their arrest. They're not above the law. They're just a man acting as the governor. They're an actor. They're supposed to act out the duties of that office. At no time are they immune from any felonies. Now, what they do talk about is immunity from being sued civilly, but it's very, very limited. And it's the burden of proof on the moving party. If you're going to sue them civilly for civil rights violations, what is the right? What is the conduct that violates the right? Don't go to Title 18, United States Code 241 and 242, because that's criminal when you're filing a civil rights violation lawsuit. You want to file a criminal lawsuit, you file a criminal complaint. You want to file a political lawsuit, that's a political complaint in the form of a petition to the legislature. So, depends on what you want to do. But at no certain time are you going to be able to do any of that without knowing this, without knowing the law, knowing what your rights are. You have to have this knowledge first. And this is what I ran into a week ago on Thursday at a meeting. I'm like sitting there saying, you know, how hard is it to fill out, how hard is it to go to uscourts.gov, pull up the form, criminal complaint A091, fill it out, take it down to the federal court, your local federal district court, and file it. How hard is it to do that? It's pretty hard when you don't know. Yeah, I see that. But in our form of government, we're supposed to go to the legislature with the redress of grievances. Been that way for a long time. The history of the right to petition has been around for a long time. This is how it's been done. Crap, I'm not even sure of the date on it, but it precedes 1215. This right's been around for a long time. Used to, petition the king. This was the king's bench. Hey, some of your officers here have done this to me. Oh, really? You got any witnesses to that? Yep, sure do. But see, this is where corruption comes in. Even back then, sometimes the witnesses would be compelled not to come testify on their behalf and be a witness to what actually happened. This evil crap's been around for a long time. So, evil is as evil does, right? So let's go back over here because I didn't get to the big surprise there with the laws for the territory of Idaho. You got to see this. This is just, it's just like amazing. Aside from this little tidbit, Article 1, restriction on the power of Congress. Number 2, rights of the people to bear arms. Uh-oh. 3, quartering of soldiers. 4, it's listed as search warrants. Uh-oh, you gotta have a warrant to do a search. Oh my gosh, no. Proceedings against persons charged with crimes and their rights. Further rights of trial by a jury. Excessive bail, construction of constitution, powers reserved to the states. Restriction of judicial powers. Mode of electing the president and vice president of the United States. Notice it stops with 12. Where's the 13th? Somebody, they're hiding it. Now, I've got evidence that it was published, because see, this is one of those published documents. But notice again that it is Article the 4th, Article the 5th, Article the 6th, Article the 7th, Article the 8th, Article the 9th, Article the 10th, Article the 11th, Article the 12th. Now, where in the heck did the Article the 13th go? Yeah, they cut that sucker out of there. And here's that Organic Act for the Territory of Idaho. Like it said, these are the laws of the Territory of Idaho. But isn't that pretty neat? That in 1863, we called them Article the 1st, Article the 2nd, Article the 3rd, Article blah, 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 blah. Not the First Amendment, the Second Amendment, the Third Amendment. No, it's Article the 1st. Oh, here it is. Oh, wait. This is the Organic Act for the Territory of Idaho. Now, what does this say? Act of Congress creating the Office of Surveyor General of the Public Lands in Oregon, and to provide for the survey and to make donations to settlers of the said public lands. Why is this in the law of Idaho? This ought to be weird. Yeah. Being enacted by the Senate and House of Representatives of the United States of American Congress assembled. Donation law to donate the land of Oregon. Because we also got land from Oregon to make up the lower southern portion of Idaho. Right here. Willamette River and the Shelby Survey, the township section, the summit of the Cascade Mountains, which now is in Idaho, not Oregon. Well, look who's making the law here. Wouldn't that be the Congress making the law? Uh-oh. Here's another act, an act to amend an act entitled an act to create the office of the, see, they had to amend it. So it's done by Congress again. They had to amend it. Now, this is from the first session. To appropriate the proceeds of the sales of the public lands to grant preemption rights. Be it enacted by the Senate and House of Representatives of the United States of America Congress assembled. What the hell? Why is this in the laws of Idaho when it's Congress making this? Just saying. Should clue some people in about how law is actually made for a territory. To secure homesteads to actual settlers on the public domain. Uh-oh. We're supposed to be able to settle? Homestead? I'll be darned. It even lays it out how it's supposed to be done. That might be worth a good read, huh? Now, abstract of the laws of the United States in relation to the naturalization of aliens. Okay, this is the law being laid down here. Well, enacted. This is actually being enacted. This was already enacted. By Congress. But this is in the book for the first session, printed, published and printed for the territory of Idaho. What's it doing in here? That's right, because there are certain powers and subject matters that were delegated to Congress, which is all of the states assembled together. So I don't see how people have a hard time comprehending that federal law applies to the states, because that's how our form of government works. That way it's uniform throughout all of the states, because all of the states sent delegates, representatives, to Congress assembled on this particular subject matter. And all of the states vote to make it and pass it. And therefore it applies to all of the states. That's called federalism. We don't have a federal government and a state government. We only have but one form of government. And within our one form of government, there are federal powers and state powers, but we only have one legislative branch, one executive branch, and one judicial branch. Those powers are separated. But at no time do we actually have separate governments. We only have one Republican form of government. But as you can see here, Congress has the power, subject matter jurisdiction over immigration, right? Sure do. So that has to apply equally to every single state, because all of the states assembled together made it. Imagine that. Ooh, yeah. Require an oath of allegiance and to support to the Constitution of the United States to be administered to certain persons in the civil service of the United States. Huh. Why is this in the law of the state of Idaho again? Let me see here. Difference of state and territory besides not part of union. Well, no, the territory is part of the union. The state is the state of being. Our state of being is free and equal, having liberty of conscience, having the law of nature, having the right to keep and bear arms, the right to peaceably assemble, the right to petition the legislature for the redress of grievances, the right to not have standing armies. That's what it's our state of being is. That's what state is, state of being. Our body politic, policy. So again, I don't know. You may have come in late, Karen. But Article 4, Section 3 is how I started with all this, is the creation, the law of creation. Under Article 4, Section 3, states may join the union. Well, the people of a territory may form their own form of government, right? Become self-governed in that territory. And you have to have the law of creation. And all of the other states have to come together, assemble in a Congress, and they create the organic act of the territory. So we're actually supposed to be a union. What is a union? A union is a league of friendship. What's a league of friendship? It's a confederacy. It's right in our frickin' face. We're a confederate republic. Federalism. Period. It is what it is. In fact, a fact of law. That's what a union is. But this is quite enlightening finding this and reading these. And I actually have, oh man, I got a few. I've found clear up to what, the 17th session, the laws of the territory of Idaho, before the Constitution was even created. This is the law, guys. And yes, under certain subject matters, jurisdiction, Congress has the authority to make this law. And it most certainly applies to the states. Because again, all states at the time assembled to make this and agreed upon it. And that's why it applies equally to all. But here's the trip, because it trips us up, is that is true. That is factual. The other part that trips us up is, well, then does that mean everything that Congress makes applies to the states? Well, if it's notwithstanding, it's not a foreign power, foreign emolument, they're not usurping their powers delegated. Yes, it most certainly does apply to the states. Because who in the heck made it? All of the states assembled together made it. So if it's under the Commerce Clause, yes, it most certainly applies to the states. But you got to be acting in foreign commerce. You know, that's actually the clear distinction there. We always talk about interstate and foreign commerce. Actually, after closer reading and then reading Federalist 45 again, it's actually just foreign commerce with the states and foreign commerce with the Indian tribes. Today's timing, it's oh, well, everything you're doing, you're acting in commerce. Okay. Why is it in the Declaration for the Cause of Necessity of Taking Up Arms that one of the grounds for taking up arms, the necessity of taking up arms, was interdicting all commerce onto the people? Because the people are supposed to be in the private. The only power properly delegated subject matter jurisdiction wise is foreign commerce and the states, foreign commerce and the Indian tribes. Hey, Mark, does Federalist Papers 6, 9, and 43 have anything to do with the Commerce Clause? Just curious. Because I know you keep posting that every time I talk about Federalist 45, and I'm not aware of anything in there about commerce. But that's what I'm specifically talking about. I could be wrong. Let's see. So here it is. Look at this. An act in relation to courts and the holding of the terms thereof in the several territories of the United States. So this is the terms, right? That the judges of the Supreme Court of each territory of the United States are hereby authorized to hold. Wait, so these are courts of the United States, are they not? So where are our common law courts that are supposed to be heard by the people, by a jury of our peers, and cannot be heard in any courts of the United States until after a jury, and then it's still on writ of review, writ of certiorari. Aha. Oh, right. Now, okay. Yeah, now that rings true about being a Confederate Republic. Yes. 6, 9, 43, and 45. Damn Skippy talks about being a Confederate Republic all throughout those 6, 9, 43, and 45. Love it. So, yes, as we can see here, where are our common law courts that are not courts of the United States? Because isn't that what the 7th Amendment says? Or, pardon me, Article the 7th. Huh. What does that say? I know we got this, right? See, they're saying here, oh, it's the 7th Amendment. No. In suits at common law, where the value contrary shall exceed the right of the trial by jury shall be certain, and no fact trial by jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. I don't know how to make it any more clear than what it says as it is written. That we are to have a common law courts. And our common law courts do both, whether it's criminal in nature or civil in nature is irrelevant. Now let's look at their little blurb here. Oh, the 7th Amendment continues a practice from English common law of distinguishing civil claims, which must be tried before a jury, absent waiver of the parties, from claims issues that may be heard by a judge alone. It only governs federal civil courts and has no application to civil courts set up by the states when those courts are hearing only disputes of state law. What a crock of crap. Our common law courts are the people's courts, not courts of the United States. You're trespassing on our property. So, the common law suits of the common law where the value in controversy shall exceed $20? Failure to state a claim for damages for which relief can be granted, whether it's criminal or civil in nature, is irrelevant. It only dictates the type of jury, whether you have to get unanimous consent of all 12 men, or if you're going to claim civil damages, not criminal damages, because again, it's criminal in nature or civil in nature. The rules of the common law and the common law courts are the people's courts. Suits between a man and a man at the common law, not in law, the body politic, policy. That's a court of the United States. That's Article 3, Section 2. Pay attention there. Look at that. In suits at common law, we'll leave that. I'll just open up another one. Yeah, I got it. Knock it off. All right. What does this say? The judicial power shall extend to all cases in law and equity arising under this Constitution. The common law came first, did it not? That's right. It's been around for a long time. And nowhere in here is there common law jurisdiction. Not in any courts of the United States. So, see that again? The judicial power shall extend to all cases in law and equity. This is at law. All right. So, as we can see and read, I mean, so long as you passed sixth grade, well, shoot, I can't even say that anymore these days. The thing is, you know, today's day and age, a lot of kids allegedly graduating from high school can't even, the literacy of them is just subpar. Imagine that. Why would they do that? Why would they purposely dumb down our kids these days so they can't even hardly read, let alone comprehend what they read? So it's easy to pull the wool over their eyes, right? So, oh, look, that was done 1858 before the territory of Idaho was even created. See, this is the law for the territory of Idaho. An act to secure freedom to all persons within the territories of the United States, be it enacted by the Senate, Congress assembled, that from and after the passage of this act, there shall be neither slavery nor involuntary servitude in any of the territories of the United States, now existing or which may at any time hereinafter be formed or acquired by the United States, otherwise than in the punishment of crimes wherein the party shall have been duly convicted. Now, wait a minute. An enactment? This is that 13th Amendment. That's not how we do that. Got to go through an Article 5 convention. This is why I keep saying that Article 13, or actually 13th and the 14th Amendments, were not done properly. In relation to the competency and witnesses for other purposes, but you know, here it's pay and emoluments of certain officers. Imagine that. I mean, this is where they got it. This is how Congress does it under certain. Oh, wait, what? This is, here it is, ready to drop the bomb. Perfect timing. We're going to end right here. Check it out. Here's the statutes of the Territory of Idaho, not the Idaho Code. An act to regulate proceedings in the civil cases of the courts of justice in the Territory of Idaho. Whoops. Huh. These are the true statutes of Idaho. Be it enacted by the Legislative Assembly of the Territory of Idaho as follows. Not the state of Idaho. And it shall be, there shall be in this territory but one form of civil action for the enforcement of protection of private rights and the redress or prevention of private wrongs, which shall be the same at law and in equity. Uh-oh. They fundamentally altered this. Because let me show you. Because see there again, it's at law, and it shall be the same one form of civil action for the enforcement or protection of private rights and the redress of private wrongs, which shall be the same at law and in equity. So it's a civil action, but is it criminal in nature or civil in nature? Because that's at law. If they violate your rights with a criminal intent, criminal in nature, it's still a suit at law. In such action, the party complaining shall be known as the plaintiff, and the adverse party is the defendant. When a question of fact, pay attention, when a question of fact not put in issue by the pleadings is to be tried by the jury, an order for the trial may be made, stating distinctly and plainly the question of fact to be tried, and such order shall be the only authority necessary for a trial. Whoops. When a question of fact, like a fact of law, oh, wait. Every action shall be prosecuted in the name of the real party in interest, except as otherwise provided in this act. But in suits brought by the assignee of an account, unliquidated demand, or thing in action not arising out of a contract, the assigner shall not be a witness on behalf of the plaintiff. In the case of an assignment of the thing in action, the action by the assignee shall be without prejudice to any set off or other defense. Boy, they probably don't want us reading this crap. Existing in the time of or before the notice of the assignment. But this section shall not apply to a negotiable promissory note or bill of exchange transferring in good faith and upon good consideration before due. Woof. An executor or administrator, trustee of an express trust, or a person expressly authorized by statute may sue without joining with him the person or persons for whose benefit the action is prosecuted. Well, wait a minute. That means you could sue on behalf of. A trustee of an express trust within the meaning of this section shall be construed to include a person with whom or whose name a contract is made for the benefit of another. Uh-oh. When a married woman is a party, her husband shall be joined with her, except that when the action concerns her separate property, she may sue alone. When the action is between herself and her husband, she may sue or be sued alone. If a husband and wife are sued together, the wife may defend for her own right. Remember, this is under common law. And if there's only one form of action for the enforcement or protection of private rights and private wrongs, can that not be criminal in nature as well as civil in nature? Yes. Yes, it can. Because, see, it's all supposed to be a civil action under one set of rules of procedure, and you can only get damages. People are not supposed to be going to jail. That is a debtor's prison. You can't pay the damages, you go to jail. No, there shall be no imprisonment for debt. That's why that's there. The Eighth Amendment, or Article the 8th, there shall be no imprisonment for debt. Otherwise, those are bills of attainder. Well, the statute says that's a crime and it's a $500 fine and 6 months in jail. That's a bill of attainder, bills of pains and penalties. That's not supposed to exist. It's strictly prohibited. Article 1, Section 9 and 10. No bills of attainder. They are strictly prohibited here. But as you can read here, the law for the territory of Idaho, when it was enacted here, and they have fundamentally altered this. Man, this is some good stuff. But there you go, folks. These are the statutes and what they're supposed to look like. Be it an act of the legislature. Section 1, where does it say Idaho Code, title? There's the title of the act, Civil Practice Act. Unity of subject and title. What is the title? Civil practice. Do they have the power to regulate this? That's right. Absolutely right, Stephanie. The remedies are quantified as damages. This, I mean, except for capital offenses, that's it. Capital offenses are murder, rape, kidnapping, abortion. Yes, I know, I said it. Abortion. It's a form of murder. It's in the common law. It's from the common law. It's in the Treatise on Arrest and False Imprisonment as a capital offense. So when you commit one of those crimes, you're supposed to be executed, sentenced to death. We don't put people in jail. We're not supposed to be running prisons and jails. Remember, a horse thief was hung? Theft violates one of the 10 commandments, doesn't it? That's right. It's a capital offense. You steal a man's horse, you're supposed to be hung. Now, one thing I want to point out here. This right here was done at a constitutional convention. All of this was done during convention, which is how we're supposed to make law, in a constitutional convention. And then only on certain subject matters. An act to regulate proceedings in civil cases in the courts of justice of the territory of Idaho. I'm curious if there's a criminal practice act. I bet there place of trial. Action of the following causes shall be tried in the county in which the subject of the action or some part thereof is situated, subject to the power of the court to change the place of trial as provided in this act. First, for the recovery of real property or mining claims or the estate or the interest therein. This is that equity. See? Mining claims, that's an equitable interest. Real property, equitable interest. Or of an estate or interest therein, equitable interest. Or the determination in any form of such right of interest, equitable interest. Those are courts of equity, of mortgage, of real property for the foreclosure. Actions of the following cause shall be tried in the, See, this lays out how it's supposed to be done. How commenced in certain courts, complaint. How endorsed, form of summons. Answer, when to be made. Notice to be inserted in summons. Notice an action affecting real property. Summons, by who served. How served, service by publication. Proceedings where service is made only on some of several defendants. Proof of service, jurisdiction when it attaches. You got to prove that you properly served somebody. Proper notice. Summons and a complaint. Gee, that's treatise on arrest and false imprisonment too, isn't it? Sure is. Here's your pleading. Oh, look, here's in the form of a demur. Demur 2. Oh my gosh. That would be section 40. Now, notice that these sections continue on. Section 36. This is Title 4, pleadings. Wait a minute. How come this stops at 35 and we go to a new title, but it starts with section 36? Because this is one publication. This is not Idaho Code, Title 18 or Title 19, criminal procedure, civil procedure, pleadings and practice. No, this is the way it's supposed to have been done. But I want to read section there 40. What is that? Short and sweet. Come on now. The defendant may demur to the complaint within the time required to the summons to answer when it appears upon the face thereof, either first, that the court has no jurisdiction of the person of the defendant, or the subject of the action. Personal jurisdiction or subject matter jurisdiction. Second, that the plaintiff has not the legal capacity to sue. Or third, that there is another action pending between. Man, this is the same crap that's in the paperwork today, except for they don't tell us about the right to object to the personal jurisdiction. And these bar members will never make a motion to dismiss based on the grounds of lack of personal jurisdiction, because they're playing their corporate Ponzi scheme with your name in all capital letters on the paperwork. That person doesn't exist, only a fiction. So they can't come after the man. That's the straw man. And it's a fiction, and it's fraud because it's under duress, threat, and coercion. And fraud vitiates everything from its inception. Comes from the contract of birth certificate. Because people forgot how the common law works when it comes to our sons and daughters being born, not our children being birthed. Two totally different words and have totally different meanings and totally different jurisdictions. Wrong person. So, in my proper person as father, that's a person. Well, somebody tries to sue me about one of their kids, their son or daughter. Well, I'm not the father. You can't sue me for child support for somebody else's child, son or daughter. You got the wrong person. I'm going to object to the personal jurisdiction. I'm not the father of that child, that son or daughter. It's not my son. It's not my daughter. Does that make sense? Or, wait a minute. Well, I want to sue somebody at McDonald's in their individual capacity, which you can do. What's their person status? Well, in their proper person, I'm a fry cook at McDonald's. Or I'm the drive-through whatever attendant, said clerk. Okay? I'm the burger cooker. I'm the milkshake maker. I'm the order taker. I'm the coffee spiller. Oh, that's right. That's why you're suing me, because I spilled coffee on you in my individual capacity while working at McDonald's. Well, McDonald's has got insurance for accidents. It was an accident. Unless you can prove it was done criminally, but you're still only entitled to the damages that it actually caused. Whether some man runs into your fence willfully, with malice, criminally, or civilly by accident, you're only entitled to the damages that it costs to fix the fence. That's just logic and reason, and that's a private right and a private wrong, and it's a civil process. Whether it's criminal in nature or civil in nature is irrelevant. Now, unless you got some sort of mental anguish and punitive damages, now you're going to have to go criminal, and you're going to have to prove that it was done willfully. That's how you get the mens rea, or that's mens rea. That's how you get the punitive damages and the mental anguish, which they've mixed it all up into civil. Oh, that's right. Title 42, 1983, you can get punitive damages. How is that if it's civil without having to prove the criminal element? If it's an accident, it's an accident. Wasn't done on purpose. How would you be entitled to mental anguish and punitive damages? So see, they've messed it all up. But nonetheless. All right, so I'm going to end there. This is some good reading, ain't it? Oh, that's old stuff. That's all been changed. And yeah, okay. This is part of the organic law of the territory of Idaho. This was all done before the Constitution was even created. And as I go through this, all of this stuff, and what I've learned here is that all of this stuff has to have been done first. And then all of this is submitted to Congress. And then Congress approves the Constitution. Just saying. All right. Hope you enjoyed the Friday night fun night here tonight. Thanks for being here and joining and hanging out and your willingness to learn. All these little tidbits here and there. It will literally empower us to have these little tidbits. And eventually you get to a point where you start putting the puzzle together. And you get enough of the pieces of the puzzle together, you start seeing the bigger picture. And the bigger picture is starts exposing the fraud. But you have to have the puzzle put together to know what is fraudulent. Because once you have this knowledge, then you know what comes in conflict with it. This is the problem we're having in today's society, is nobody knows the fundamental law. Nobody knows the fundamental principles. We don't have this knowledge. So how are we going to know how it's fraudulent? To go out there and say, oh yeah, the birth certificate and your social security number and your whole trust thing, and you're being trafficked and blah 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 blah. What? Without teaching them the fundamental principles first, how are they going to even begin to comprehend and understand that that's all fraud? Can't even begin to make a lawful argument because you don't know the law. You don't know the fundamental law. You don't know what your rights are. You don't know what your rights to a Republican form of government are. And without this knowledge, you ain't got no power. Period. It's a fact. But I love my fellow man enough to be here to do my best, whatever I can do here to help educate my fellow man. So thank you all for being here and hanging out on a Friday night and having a little bit of fun, getting ourselves educated and learn how to kick the crap out of these public servants who trespass on our rights. That's right. Common law trespass on our property, an aggregate of guaranteed rights. So, if you'd like to help support the channels here and help pay the bills, I'd greatly appreciate it. You can send those things over to the office through the snail mail at 6477 West Fairview Avenue, Suite C, Boise, Idaho, 83704. Digital side, PayPal, Kirk_Pendergrass at hotmail.com. Cash App, $, capital K, capital PEN 71. And for those of you who'd like to join us over there on Wednesday night workshop on Patreon, get signed up over there. Let's get her going. Let's build a nationwide team over on Patreon. Okay? Let's really dig into how to create these documents, how to effectively defend yourself, and how to go tell on them. You got to know how to do these documents, period. There is no ifs, ands, or buts. And you got to have the knowledge first, right? Fundamental principle, 2 + 2 = 4. You got to learn what the plus sign means, the minus sign means, the multiplication sign, the division sign, the equal sign. You got to learn the fundamentals before you can even begin to do math. You have to learn what those things mean. So, thank you all for being here. Much love. Hope everyone has a wonderful weekend. We'll see you back here on Monday Night Law, back over to the commentaries on the Constitution by Joseph Story, which I want to give a little tip. There's actually what they call 3 volumes. I've been reading some other stuff, and it's like it keeps referencing subsection, blah, 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 blah. And I'm like, I go to my PDF. I'm like, where in the heck is this subsection? This thing ends at like 600. Well, it's saying to go look at subsection 1700. Where in the hell is subsection? Well, come to find out, they call them volumes, and there's 3 volumes. I now have all 3, just so you know. So, we're going to have a little bit more eye-opening stuff when we start going through the commentaries on the Constitution all 3 volumes, not just volume 1 that has 3 books within it. I thought that one volume was all 3. It's not. There's 3 books, but there's also 3 volumes containing 3 books. But anyways, much love, everybody. Have a wonderful night. And we will see you here on Monday Night Law. Night, everybody.